Hello everyone, I am Stuti Ajmera, second year law student, currently pursuing BBA LLB from United World School of Law, Karnataka University. Currently, I am interning in Sejpal Associates Advocates. In this video, I'll be talking about what is trademark and trademark infringement, and further we'll be analyzing the case of Starbucks versus Sardarbuksh. Let's start with the introduction. What is trademark? According to Section 2, Clause 1, Subclause ZB of the Trademarks Act 1999 defines trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or services of one person from those of others. It may include shape of goods, their packaging, and combination of colors. Trademarks are important corporate assets. If a different company seeks to use the same or a similar mark after registration, a relevant legal process will be available to prevent it. A trademark is valid for 10 years and it can be renewed indefinitely if further payments are paid from time to time in the manner prescribed by the laws. What is trademark infringement? According to Section 29 of the Trademarks Act 1999, it is defined as a registered trademark is infringed by a person who, not being a registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which is identical with or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered, and in such manner as to render the use of the mark likely to be taken as being used as a trademark. When a trademark is violated, both civil and criminal legal action may be taken. A criminal complaint may be submitted by the complaining party. The Trademarks Act of 1999 acknowledges trademark infringement as a cognizable offense. Now we move forward with the case of Starbucks versus Sardarbuksh. It was held in High Court of Delhi. It was a single bench judgment passed by Justice Manmohan. Now the facts of the following case were as follows. Starbucks is a corporation, well-known brand on a global scale. In 2001, they had registered their wordmark, Starbucks, and associated logo, which featured a crowned maiden with long hair under the Trademark Act 1999. They are very well known internationally, and their name as well as their logo have significant goodwill. In 2015, a coffee shop named Sardarbuksh was launched in New Delhi. Their Sardarbuksh Coffee and Co. name and logo were remarkably similar to Starbucks, and they operated multiple stores throughout the Delhi. The logo of Sardarbuksh featured a turbaned commander's face with wavy lines on either side encircled by a black circle. In 2017, Starbucks wrote to Sardarbuksh regarding the violation of trademark. Sardarbuksh changed their logo by changing their color scheme to black and yellow in response to that notice. Later, they restarted their operations but kept using the same name. In 2018, Starbucks filed a lawsuit against Sardarbuksh in Delhi High Court for using the term Sardarbuksh, alleging that their names were deceptively similar. But according to Sardarbuksh, their name's interpretation is entirely distinct from Starbucks. Thus, they couldn't be said to be confusingly similar. The issue of the case is whether the defendant's mark is deceptively similar to that of the plaintiffs. The relevant provisions for this case is Section 2, Clause 1, Subclause H, to be read with Section 11 of the Trademarks Act. Section 11 of Trademarks Act states that the registration of a trademark may be refused or denied if it is identical or deceptively similar to a pre-existing mark. Section 2, Clause 1, Subclause H of the Trademark Act states that deceptively similar, a mark shall be deemed to be deceptively similar to another mark if it so nearly resembles that other mark as to be likely to deceive or cause confusion. The judgment of the case was the court established a number of criteria to establish misleading likeness, including the likelihood of confusion, goodwill, and others. The court relied on the case of National Sewing Thread Cooperative Limited versus James Chadwick and Bros, where it was held that deceptively similar could only be determined by stepping into the customer's shoes under the presumption that he is a man with ordinary intelligence. If the customer feels confusion while differentiating the two brands, they can be deemed deceptively similar. Further, the fact that both the parties, Starbucks as well as Sardarbuksh, were dealing in the same kind of trade and offering same services to the customers, it also plays an important role. Also, in the case of Miss Nandini Deluxe versus Miss Karnataka Cooperative Milk Producers Federation Limited, it was held that due to difference in the variety of products traded and difference in visuals of both the companies, the trademarks Nandini and Nandini will be considered to be non-infringing. The plaintiff, the Starbucks here, was awarded a favorable judgment by the court. On August 1, 2018, the High Court of Delhi ordered the defendants to change the name of their 20 stores that have not been yet opened from Sardarbuksh Coffee & Co. to Sardarji Baksh Coffee & Co. However, the court allowed the use of the current name Sardarbuksh Coffee & Co. for their two operating stores. On 27 September 2018, the parties exchanged terms and conditions, and these were recorded with the High Court of Delhi. As a result of this concession, the defendant, Sardarbuksh, renamed all of its outlets Sardarji Baksh Coffee & Co. Additionally, it was decided that the defendant would have the right to launch a lawsuit against any unauthorized use of the term Baksh by a third party. Thus, the dispute at hand was resolved. Thank you for watching this video.